Stay tuned for the next edition of Zoom Landlord-Tenant Talk Radio. This represents our 1-year anniversary show. The topic today will be security deposits, all you need to know. Well, hello, everybody. Yes, another edition of Zoom Landlord-Tenant Talk Radio. It is September 14th, 2024, and we have a special day today because this marks my first 1-year anniversary for doing Zoom Landlord-Tenant Talk Radio. This year has been a lot of fun for me, and I'm always trying to give back to the community. And I think that as time goes by, I've gotten a little better at the production of this. So I do want to thank everybody for their support and well wishers for us doing this. And my belief is I'm going to keep doing this every Saturday at 3 p.m. The name of the song that you heard was You Are the Reason by Callum Scott. Just one beautiful song. And I hope you guys enjoyed it. We have a topic today, as I always do, and the topic is security deposits, all you need to know. Security deposits, all you need to know. And so a lot of landlords get into trouble with security deposits. Either they just don't know what to do with it, or they don't return it. And it's interesting that every landlord knows that when they're renting out an apartment, they're going to take a security deposit, but they never know what the rules are. They never know how you have to return it, what itemizations are required. So I'm going to give you a little tutorial today, which should encompass everything you need to know. Okay? Now, when you're renting out a unit, you need to request a security deposit. You do not call it a last month's rent. You do not call it a non-refundable cleaning charge. You call it a security deposit, okay? And that should be stated in your rental agreement. You want to make sure that you never have a tenant request, or at least the particular applicant request, that he wants to pay the security deposit in payments. If you agree to that, I guarantee you'll be calling my office and we'll be doing an eviction. That'll never be paid. And if he doesn't have the wherewithal to pay a security deposit, then that's a pretty good credit indication that this person will not work well in your building and you will be bringing forth an eviction. Now, how much of a security deposit can you take? Well, the law changed on us, ladies and gentlemen. And as effective July 1st, 2024, you're entitled to only 1 month's rent, a 1 month's rent security deposit. So if your rent is $2,000, you can only get a $2,000 security deposit. Now, there is an exception. We've talked about it on previous shows, and that is if you own no more than 2 buildings with a total of 4 units, then you are entitled to a 2-month security. And by the way, the law does not care anymore whether it's a furnished or an unfurnished unit. But if you have no more than 2 buildings with a total of 4 units, you have the right to ask for a security deposit equal to 2 months' rent. Now, if you had, for example, a 3-unit building and a 4-unit building, then under the law, you would not qualify. But the way to get around that would be to put the 4-unit building into an LLC. That would be a different ownership entity, and therefore both units, the 4-plex and the 3-plex, you'd be able to get a security deposit when the tenant is coming into your unit. Of course, if you have a 5-unit building, there's nothing you can do. If you did have a 5-unit and a 4-unit building, then of course I would put the 5-unit building into an LLC, and this way the 4-unit building would qualify. Okay. Let's talk about something that no one ever follows with regard to the laws regarding a security deposit, and that is that there has to be, if a tenant is giving you notice that they're vacating, or consequently, you're serving your tenant a notice to vacate for a non-fault matter, like a 30-day notice that I'm going to have a family member move in, etc. Not a fault matter like non-payment of rent. But if you're serving a 30 or a 60-day notice on your tenant, which does not involve fault of the tenant, then you have to offer that tenant an inspection requirement prior to the end of that notice period, which means that you have to offer him the right that we're going to inspect your units prior to you leaving. So you have to offer that so that you can show him what items are going to be deducted from the security deposit and giving your tenant the right to take care of it himself. So you should send him a notice as soon as you know that the tenancy is going to be tenant terminated or your tenant is vacating, and give him the option of having this inspection of the unit. Now, no one ever does this, but this is the law. And you can get into some situations where a judge will frown upon you if you deduct items from that security deposit. So you have to notify the tenant of the right to ask for an initial inspection so that the tenant has a chance again to fix any issues or avoid any charges. The tenant must ask for that inspection within 2 weeks before the tenant moves, and the tenant has the right to be present when you're doing the inspection. So you can do it with the tenant, but if he asks for it, then technically you have to do that inspection, and you also have to offer that. So on my website, evict123.com, if you go to the free form section at evict123.com and you scroll down to the bottom, I'm going to show you what the form looks like because I just put it up today. And there we go. So that's the form, notice of inspection. Prior to the termination of tenancy, you put in the tenant's name and address, and that you explain to him when the tenancy is going to be terminated. And then you put in the date. That would be in this section here, if you can see my cursor. You put in the date that you want to inspect the premises, and he can agree to that, or he can check the second box here where he's going to ask for a different time. And you have to be accommodating where both of you agree on a time at that point in time. So again, this is on my website, this form. It's in the free form section. Scroll down to the bottom because I just put it up about a few minutes ago, and feel free to use that form. Now, again, this is anytime the tenant gives you notice that he's vacating or you have served a non-fault notice to the tenant to vacate. Okay? All right. Now, let's move on with regard to our tutorial in reference to security deposits. So when the tenant does vacate, you have the right to deduct items from the security deposit. So what are the items that you can deduct? And that is those items where there has been unusual wear and tear to the property, unusual wear and tear to the property. So what does that mean, unusual wear and tear? Well, what happens, for example, ladies and gentlemen, where a tenant gives you notice, leaves on the day that he's supposed to, has paid all the rent, you meet him in front of the apartment, he hands you the key, and he says goodbye, owing you no rent. And you open up the door, and you see that the carpeting is ripped to shreds, ladies and gentlemen, ripped to shreds. Would that be considered unusual wear and tear? And the answer is no. And you're saying to yourself, how could that not be unusual wear and tear? Well, you see, what I didn't tell you and what you guys didn't ask is that the carpeting was 35 years old. And 35 years old carpeting is going to be ripped to shreds. So when we talk about wear and tear, again, we talk about unusual wear and tear. So for example, If a tenant puts up a bunch of pictures and you got nail holes, can you charge him for unusual wear and tear to spackle and repaint those areas? And in my position, trying to be very conservative, is that you can't, because everybody puts up pictures who moves into a unit. Look right behind me. I've got pictures posted. So I don't think that would be considered unusual wear and tear. Okay. But if you come in and you see cabinet doors are ripped off the cabinets, or you see that there's holes in the walls from where your wonderful tenant was punching holes into the wall, or you see that one of the bedrooms is painted chartreuse because he just happened to like that color, that would all be considered unusual wear and tear, and you would be able to deduct that from the security deposit. Now, you can also deduct from the security deposit actual and reasonable cleaning charges. You can't have a prefixed, I'm charging $220 for cleaning the unit. It has to be what it reasonably and actually costs you. So if you hire a service, XYZ cleaning service that comes in and does it, then you have the right to deduct that invoice. The last thing that you can do is you can deduct any rent owed. If the tenant owes you rent, that's a prime area of what can be deducted from the security deposit. Can you deduct late charges from the security deposit? And the answer is no. You can only deduct rent. Now, if you happen to have a phrase in your rental agreement that all items owed under the rental agreement are considered rent, then you actually can. I know I have that in my rental agreement that's online. So remember, there's only 3 items that you can deduct from the security deposit, and that is unusual wear and tear, reasonable cleaning, and unpaid rent. Those are the items. Now, once you determine that, you've got 21 days to send an itemized statement to your tenant. 21 days to send that to the tenant. Now, you might say, well, I couldn't send it because he never told me where he was moving to. Well, if you don't have a business address for him and you don't have a place where he has now moved to, the law requires that you mail it to the last known address, which would be your property. So mail it to the last known address, which is your property. And if it gets forwarded because he put a change of address, great. If it comes back to you, what you do is you keep that envelope, do not open it, leave it sealed. You'll have proof that you did send it. The only one who would ever open that envelope would be a judge if you're being sued in small claims court. Okay? Now, what if, for example, you are deducting $125 or more for unusual wear and tear or cleaning, etc.? Then you have to submit invoices proving those amounts. So that has to be included in with your itemization. So be sure that that itemization is mailed within 21 days, and make sure that if you're deducting $125 or more, that you have receipts, invoices, something to prove that. Now, what if, for example, you know what, I do my own cleaning. Are you allowed to deduct the labor for your own cleaning? And the answer is yes. Or maybe you have your manager do it. If that's the case, then you need to create an invoice showing how many hours were worked and what was the hourly rate. That's also perfectly permissible to do that. Okay. Now, what happens if the damage is so extensive that you can't get the invoices within the 21-day period? So then what you'll do is you send the tenant a reasonable estimate explaining that the invoices, because of the extensive nature of the damage, cannot be obtained within the first 21 days. And then the law says that after you send that, you've got 14 days to send them those invoices once the work has been completed. So once the work has been completed, then you send it to the those invoices to the tenant, and you have 2 weeks to do so. Now, if you improperly deduct, this goes under the concept of penalties, ladies and gentlemen. If you improperly deduct items from the security deposit, or you don't send them a security deposit itemization at all, you're going to find yourself in small claims court. And when you find yourself in small claims court, ladies and gentlemen, you're going to lose because you're the landlord. Landlords always lose in small claims court. And if the judge finds that your actions were in bad faith, the tenant can not only be awarded that security deposit back, but also twice the amount of that deposit as a penalty. This is under the code, Civil Code section 1950.5, if anybody is curious. So that is my treatise on security deposits, all you need to know. Remember that form that you have to send to the tenant once you know the tenant is going to vacate. As soon as you know, send that form and give that tenant an opportunity to have a inspection, a pre-inspection with you. Nobody follows that law, by the way, and I don't want to see you guys get in trouble. Okay, that ends my topic of the day. We're now going to open it up to questions and answers, ladies and gentlemen. Questions and answers. We know the ground rules, and that is that this podcast is for informational purposes only. It does not constitute legal advice. If you want to talk to me and ask me a question, please electronically raise your hand. If you're in the Zoom meeting, that's on the toolbar, you'll see a hand. Just click on that. I see we already have 9 people. I'm going to try to get to everybody today. And last but not least, if you have a case with me, we do not discuss specific cases, only general information. And with that, kicking off my 1-year anniversary, we're going to go to one of our favorites, Jim Polina. I'm going to ask you to unmute yourself. And I see you're very busy making this ADU.
That's right, Dennis. That's right. This is my very favorite part of every Saturday. So
I thought I was your favorite part, Jim.
You are this part of Saturdays. So
Okay.
I got a question on topic security deposit.
Okay.
This tenant that moved out, wonderful tenants, they're going to get back their security deposit. But my question is the timing, the 21-day deadline. They were required to give a 60-day notice, which they did, and then they vacated 30 days into the 60 days. So that's why I'm taking advantage of this vacancy to do this work. So they're paying the last 30 days and not living here. When do I give that security deposit back, from the day they move out or the end of the lease?
Okay, the law says specifically 21 days from when the tenant vacates the unit. The tenant has vacated the unit, even though they might be financially responsible for that extra month, but they did vacate the unit. I would send it within 21 days.
Okay, that clears that up. Second question. You mentioned a while back about landlords providing a refrigerator as an accommodation, as a courtesy, meaning that if it breaks or fails, they don't have to replace it. Do I have that right?
I think you do, but it has to be stated in the rental agreement that the tenant, if they want, can use this refrigerator or it will be taken out, but it has an accommodation and the landlord has no responsibility to repair it if it's broken. I put that language right in there. So
here's the curveball for you. Can I use the same language for the air conditioning system?
Are you talking about central or window air conditioner?
Forced air.
I don't think so.
You don't think so?
Yeah, no, that's a built-in appliance. It's not like a refrigerator that you can take out.
Okay, great.
Thank
you, Dennis.
Always insightful questions, Jim.
Thank you.
Good luck with the ADU. Remember, I'm going to be moving in there, so make sure you charge me a little rent, okay?
Let's hear it for Pismo Beach.
Okay. Okay, we are moving on to NDCP. I'm going to ask you to unmute yourself, please.
Good afternoon, Dennis, and congratulations on your 1-year anniversary. That's a blessing, and may you be able to continue it till the Lord return. Amen. We're a single-family dwelling, owner-occupied, and someone mentioned to me, because we have to get this person out, that there's a larger law, that a larger is different than a tenant because we're living in the single-family dwelling. If we were not, he would be a tenant, but because we are, he's a larger, and there's a larger law that actually can help move him out. Are you familiar with such a law?
Yes, I am. It's under 1946.5 of the Civil Code.
Okay,
And where you have one person living with the owner
right.
and the person has a bedroom, but the person has use of the house. In other words, he can use the kitchen, he can sit in the living room. Then that person is considered a lodger. He's not a tenant. And in that situation, only a 30-day notice need be served, even if the tenant has lived there longer than 1 year.
Oh, okay. So that's an avenue. And the enforcement of removal if they choose not to go.
Well, actually, it's funny that you should say that. Under that civil code, it says that if he stays beyond the 30 days, he's considered a trespasser under the law and can be arrested. But no one will, no police department will follow that law in my 48-year career. So you're going to need to go through a regular eviction.
A regular eviction. Okay, just on the flip side, is it legal to rent out rooms in such owner-occupied single-family dwelling in Los Angeles?
And the answer is no, it is
Oh,
not. And I really frown on my clients who do it, but so many of them do, because obviously um, it's a it's an economic reasons why you're going to make much more if you're renting out rooms than if you just rent it out to one family. But I really tell you, in the city of Los Angeles, you can get into a heap of trouble. We had one of my clients years ago bought a Victorian house, and Victorian homes are notorious for having a lot of small little bedrooms. They had literally, the previous owner had literally rented out 15 rooms. The city declared that that's a boarding house. You didn't have a license to run a boarding house. And on that basis, those were all considered illegal tenancies. And the city was forcing them to pay relocation of thousands of dollars to each of
totally.
those tenants. So I'm not a fan of doing that, my friend.
I see. And the permit is
It's
from the
called a
city?
boarding house permit, but the city's
Okay.
not going to give you one. So you don't have to worry about
Uh,
it. But if you
boy.
have one, then I think you're good to go. I'm going
Okay,
to move on. Thank
last
you.
question. Dennis, quick question.
Yes.
Just is it easier to get a jury trial judgment for a nuisance, just cause ordinance nuisance or non-payment of raised rent?
There,
Jury trial.
it wouldn't make any difference. I mean, if you have
Okay.
the facts to win on a nuisance, you can win in front of a jury. If you have the facts to win based on non-payment of rent, I know my firm just, and I tweeted about it, in the last 10, 12 days, we've won 3 jury trials back to back. So landlords shouldn't be afraid that they're going to lose in front of a jury. We win in front of juries. We're the ones who bring forth the lawsuit. So we know where the tricks and the traps are. So I wouldn't
Yeah.
be afraid that, oh my God, the jury's going to be full of tenants and therefore they're not going to vote
Yeah.
in favor of the landlord. That's a fallacious thinking. And with
Okay.
that, we are going to move on to Austin. I'm going to ask you to say hello.
Hi, Dennis. Thank you for your year-long commitment to giving back to the community and educating us on all this stuff. It's just wonderful that you do this for us.
My pleasure.
Yeah. So my question is creative ways to serve a lawsuit. And my tenant is under the CARES Act, and so we're coming up on that 30 days. And the tenant has not moved out. So I want to replace, and so I have a feeling she's going to try to evade the eviction lawsuit because she knows it's coming. And so what I want to do is get in there and replace a faucet. She's pretty open to me coming into the unit to do repairs. So I was just going to go in there, replace a faucet. She usually likes to be home. And then upon exiting the unit, I was just going to say, oh, by the way, here's some paperwork. Have a nice day.
Well, first of all, Austin, are you the owner of the property?
That's correct.
Okay, an owner cannot serve a lawsuit. It would have to be somebody else who's over the age of 18. And while we're on this subject, can you tell me the best day of the year to serve a lawsuit?
I cannot.
Well, I can. Do you know what that day is? It is Halloween. Halloween's a great day to serve. It's coming up because you knock on the door, they're expecting the kids and look at you sitting there and handing them a lawsuit. You can't hand a tenant a lawsuit if you're the owner. You need somebody over the 18 who's not in your employ. Now, if we are talking about an unlawful detainer lawsuit, it's not that big of a deal to serve because if in fact the tenant doesn't open up the door, and a lawsuit generally has to be put into their hand. When you're serving notices, you can post it on the door and mail one. But if you're serving a lawsuit, that's got to be put into somebody's hand, or at the very minimum, drop it at their feet. But what if they're there and they just don't answer the door? So in that situation, there is another procedure under the law just limited to unlawful detainers, eviction lawsuits, and that's called an order to post. So once we get a declaration from the process server that they've been there 3, 4, 5 times, then we can apply to the court for something called an order to post. That's a motion that we file with the court, which the judge will sign. Once he signs it, then we have the right to serve the tenant by just posting it on the door and mailing it by certified mail. That will then be considered proper service under the law, but again, it requires a court order, and it also that court order requires that we show a declaration of attempts of how many times we've been there and what times of the day.
Okay, so what I'm hearing is that it's just more streamlined to hire a process server than to try to DIY this.
Oh yeah, you should hire a process server because they're going to claim that they didn't get the paperwork, even if you or let's say a friend handed it to them. But if you have a licensed process server, then generally the judge is going to believe the process server who's licensed.
Okay. All right. Thanks, Dennis.
All right. Thank you, sir. We are going to move on to one Irish woman by the name of Margaret O'Brien. Say hello, please. Margaret, are you there? I assumed you're Irish with the name O'Brien. Well, we'll give you another chance a little bit later. Al, I'm going to ask you to unmute yourself.
Hi, Dennis.
Hi.
I have a single family home in North Hills. They are month to month. How many times in 1 year can I raise their rent?
As much as you like, but if in any 1 year period you go above 10%, then you need to serve a 90-day notice of rent increase. And then you also have to remember that when you send that, you have to allow an additional 5 days for mailing. So that would be a 95-day notice.
It doesn't matter if they're like both over 60.
The age of the tenant has nothing to do with raising rents. Okay, if you have a single family home with only one house on the lot, you are not subject to any rent limitations. I don't care how old the tenants are. I don't care that you own the property in a corporation. I don't care that you've raised that rent before the same year. You have the right under current California law to raise that rent to market value. I've got a rent increase notice on my website at evict123.com. So feel free to use that. And if you're going to do that now, for example, in the month of September, then it's going to take effect January 1st, 2025, because basically you don't count this month. And then you got October, November, December, that's your 90 days. And plus the 5 that would be part of September. So you'll take effect as of January 1st, 2025.
That's if it's over, if it's above 10%. Is that correct?
Yes. Otherwise, it's just a 30-day notice plus 5 days for mailing.
Okay. The way I understand it is you're adding like the rent increase I already did. If the second rent increase is below 10%, adding them both together.
Yes, you have to add them both together. So let's pretend you do a 6% rent increase in January of 2024. And therefore you only served a 30-day notice plus the 5-day mailing rule. And now this month you want to raise the rent 5%. Well, now within any 1 year period, you're above 10%. So you're going to need to serve a 95-day notice for that 5% rent increase.
But if I raise it like 4%, make it 10.
Then you're fine because you're not above.
30 days, right?
Yep.
Okay, thank you.
Thank you. I'm going to go back to Margaret. I think you're probably going to be ready now. I'm going to ask you to unmute yourself. Margaret O'Brien.
Yes. Hello, Dennis.
Hello, Margaret. Look at you.
Yes, and you and I go back many, many years when you were fresh out of law school. And
Oh
when
my God.
yes, and we won the case at the time.
Oh,
So
well, thank you very much.
yeah. Okay, so Mike, I have three questions. With the security deposit, they talk about interest. Do we have to pay interest?
Well, first of all, what city is your property located in?
Oh, in San Pedro, rent controlled, all rent controlled.
Okay, so yes, the city of Los Angeles requires that you pay interest on security deposit, and you have to pay that on a yearly basis. I should put that up on my website, but if you just do a Google search for interest on security deposit, City of Los Angeles, you'll see their form will pop up, and it'll tell you for each year. Now, the interest rate is so low, it's like less than 1%. It's like 1/10 of 1%. If you haven't done it in 20 years, it's not even going to exceed $25. So just give them a check for $25. Now, I actually have, and I'm surprised Jim hasn't found this one out yet, but in my rental agreement, I have a phrase just in case to kind of save ourselves. Because if you don't pay the interest on security deposit in the city of Los Angeles, and we're now going for non-payment of rent, your 3-day notice has to state the exact amount of rent owed. So tenants' attorneys are trying to say, well, you didn't pay the interest on the security deposit, so therefore you act and you should have paid us, so therefore you owe less, and therefore your notice is defective because it's overstated. So I've got a phrase in my rental agreement that says that we charge a management fee on a yearly basis of 4% that has to be paid each year on the anniversary of the inception of the tenancy. However, we will consider that in lieu of paying you interest on security deposits. So I've phrased it in such a way that you're going to actually get around, and especially if you didn't do it and you're facing a problem on an eviction case. So, but again, it just makes more sense. Serve the notice with the letter giving him the interest. And by the way, I don't even know what it is just this year, but it might be 0.3%, for example. So it's hardly any amount of money. So if you haven't done it in years, give him $25 and call it a day.
Okay, and then I have another question again under rent control. I have a vacancy, and I had mother and son who want to rent the unit. The mother is an American citizen. The son is undocumented, and the mother leaves a very, very good impression. Is there a way I can rent to the mother only and let her son live there? I mean, he's over 20 years old. He's probably 25.
I get this question a lot, and there is no reason to do that. Put both of them on the rental agreement. They're both responsible. What if the son gets a big paying job? You want to be able to go after as many people as you want. It's more to your advantage. So every adult who's moving into your unit, assuming you want to have them move into the unit, every adult signs the rental agreement. Every adult does the credit check. Every adult fills out the application.
Okay. And then my last question is, this is again regarding a change of management and ownership. We did not change management or ownership, and I will have to give the people my home address. But could I give them an UPS store, that is manned by people?
And the answer is
No.
no.
Okay, that's what I was afraid
You got to
of.
have a specific person who will accept it. At a UPS store, you don't know who the guy is that day, so that
No,
doesn't
that's
work.
true. Okay, that's
All right.
all.
Good
Thank
question.
you very much.
All right, take care. And thank you for following me for so many years.
Well, yes, and my husband remembers that you had a very good-looking secretary in your office.
Well, I think they're pretty good looking now as well. But what was your husband's name?
Benedict.
Okay, Benedict.
Yes.
Okay, well, thank you very much.
Okay.
So we actually, my practice, as you guys probably know, go all the way back for 48 years. It's insane. Anyway, let's move on. Diane D., how are you today?
I'm good, Dennis. How are you?
I can't complain.
Dennis, I think my dad used to use your firm. Were you with Michael Katz also? Was that?
Yes, when my firm started my firm started in 77 and I joined up with a individual by the name of Michael Katz, a very, very nice person. He was actually in law school with me and we changed the name of the firm to Katz and Block. But Michael got a little bored and in 1988 he left and the old man is still here plugging away. But yes, it was called Katz and Block to start as we walk down memory lane here.
Yes, yes. Um, Dennis, I have two situations, and one you sort of addressed, but I had raised rent because I have very below market rent. So I had raised rent on a few properties earlier in the year, and then I had some problem tenants, so I decided to raise rent on them again. And now I'm seeing that because I'd already raised rent 10%, I should give a 90-day notice. So I have one of the 10% coming up for October that had rent already raised at the beginning of the year. And then I did a 90-day to raise it even more in December. Should I just text them and tell them disregard the October that continue on and then the
Tell
90
them,
days?
yes. Yeah, tell them that second notice after the first one that you served is improper. Just ignore it. And then I'm going to serve you another notice that will be 90 days. Correct.
Okay, and so I'm so nervous about Prop 33. You think if everybody's been served with 90-day notices to start paying higher rent in January, that if proper,
I
don't
don't think it's going to take effect that quickly. Remember, even if Proposition 33 passes, and by the way, everybody vote no
Yes.
on Proposition 33 and yes on Proposition 34. But if it passes, all that means is that the local municipality can then extract a pound of harm to landlords. So I don't know if it passes in November, I don't know how quick Los Angeles, for example, or West Hollywood or Santa Monica or any of the other places that have rent control would immediately institute some harsh new rules that they now have the right to do. So again, everybody, I've got a big sign up in front of my building that says no on 33. This is going to decimate our industry because, as we know, if that passes, a municipality like Santa Monica tried to do can do away with vacancy decontrol, which means you have a vacant unit and they're going to tell you what you can rent it for. This is criminal.
Correct. And I'm emailing everybody I know. So the other situation I have is I just found out a couple of tenants have these above ground pools that they've put in, and they're really excited about it. But what's my liability? I mean, should I tell them to remove those or?
Absolutely. You don't want them to grow above ground. I mean, people can drown in that, then they're going to try to hold you responsible. So no, that is not permitted under any rental agreement. It's an alteration to the premises. And you tell them they got to get rid of it immediately.
No, even if they offer to put on, there's probably not a high enough coverage on rental insurance, correct?
Yeah, I would not allow that in your building. And if they refuse to do it, the alternative would be to go to Home Depot and get yourself a hammer and a nail.
Okay, that sounds doable.
Okay. All right. Thanks, Diane. All right. Now we're going to move on to an iPhone. I'm going to ask you to unmute yourself. *6, I believe, does that if you can unmute yourself. There you go.
Hi, my name is Cheryl, and I just have a quick question. I'm in the process of having someone served, so I'm suing them for eviction. Does any of that reflect on your credit report? the landlord credit report?
No, of course not. You're not being sued. You're the one who's the plaintiff bringing forth the lawsuit. Of course, that would have no effect on your credit report.
Oh, okay, and then if for any reason, I don't know why, I'm just throwing this out, if they decide to sue the landlord, then does that show on the
No,
credit report?
that again wouldn't show you. The only way it's going to show on your credit report, and that's for the tenant as well, is if you lose and there's a judgment against you. If there's no judgment against you, somebody's just filing a bunch of lawsuits, that doesn't have any effect on your credit.
Okay, thank you.
Thank you. Good questions. Okay. I'm moving on to Alexander. Hello, Alexander.
How you doing, Dennis?
I am good, thank you.
Just clarification on the security deposit rule for a fourplex. You mentioned LLC would be exempt. What if it's in a living trust?
Living trust would not exempt it because that's still considered the same owner. But that's a good
Okay,
question. By the way, I see you're with 21st Century Property Management.
Yes.
And what territories do you serve?
I take care of Corona and Riverside and San Bernardino, Marietta. Basically 20-mile radius from Riverside.
And how long have you been doing it?
Property management, 11 years. Real estate agent, 28.
Oh my God, 28. And do you have any horror stories as a property manager?
No, most of my tenants are good, but I have colleagues that have had horror stories with it was the COVID. One of my colleagues had 4 people that stopped paying. And it was a mess trying to get them to.
And just in case anybody has any property out there in that area, what's your phone number? What's your office number?
Office number is 951-850-5655. Thanks for the shout out.
Hey, no problem. And by the way, we do put this up on YouTube so people can watch it. So if you missed the phone numbers, ladies and gentlemen, now just catch the show on YouTube. Anyway, thank you very much. We are going to move on to Arlene. I'm going to ask you to unmute yourself.
Hi, Dennis.
Hi there.
Nice to see you.
Nice
Happy
to see
anniversary.
you. Well, thank you.
I appreciate all you do for us and the time and dedication you've done in educating us. I just have a quick question in the weeds. LARSO regarding interest payments to tenants. I believe that for 2024, it's actually 0.52%, which is a lot higher than it's been the last few years. And it used to be that you didn't have to pay it yearly, you could pay it as a lump sum, but I'm just curious whether that has changed, and also whether it used to be that you didn't have to pay it on the first year of the tenancy. Do you know whether that's still accurate?
You don't pay it the first year because there's no interest gained. It's supposed to be paid every year. There's never been a change on that. I just pulled up the form, and as I look at this here, let's share the screen here, since I can do that. And let's take a look here. That's screen 1 and share. Okay, so you can see here that can I make that bigger? Maybe not. You can see here, for example, that in the year January of 2024, right at the end here, it's only 0.52%. So that's less than 1%. And if you hadn't done a rent security on interest, but now we're only talking RSO properties for the city of Los Angeles. So don't think that, oh my God, my property's in Burbank and I didn't do it. No, this is only for the city of Los Angeles whose property is subject to the rent stabilization ordinance. But if you can add up all those percentages from the year 2000, it's not going to add up to much. So I would doubt that you'd ever get above even $25. So there's the form, and you can just Google interest payments on securities, City of Los Angeles, and you will find that form as I just pulled it up real quick.
Thank you very much.
All right, you have a good day. Okay, we are moving on to Sonia. Sonia, how are you today? Miss Sonia.
Yes. Hi, Dennis.
Hello.
Hi. Thank you so much. My question is how best to handle a tenant or who is kind of when there's a repair needed or something, they tend to exaggerate quite often. And as far as what it is, it's like something is terrible, oh my goodness, or whatever. And it's something so minor. We try and communicate as far as, yes, we'll be there to repair it and everything's handled in a timely manner. But how best, I mean, I'm a little concerned, or you tell me if I need to worry about the language of her messages.
Well, I
Because then,
mean, regardless of how she's communicating to you, if there's an issue with the apartment, you go in there and you correct it in a very short period of time. I would also send the tenant, as I was telling on other broadcasts, a confirmation letter that you called very upset that that there was, let's say one leak in one bathroom, that let's pretend the sink was dripping, and even though this is not a major thing, we immediately within 24 hours fixed it. So kind of throw it back at her that she over exaggerated the problem, but in any event, you took care of it.
okay, perfect. Thank you so much. I appreciate that.
Good question. We are moving on to Mrs. H. How are you?
Good afternoon. I just have two quick questions.
Sure.
At the convention, you mentioned about insurance, that we could maybe pay part of it to the California insurance company and another part to our main insurance company. Do you remember saying something about
I
that?
do. Under the California Fair Plan, okay, for example, my house that I'm sitting in right now, insurance canceled. I was with a couple a few nights ago and their insurance was canceled. And we're getting apartment buildings that are canceled, but a lot of these companies that are canceling you will still allow you to take the liability insurance. They're just not going to insure you for fire. So under the California Fair Plan, you can get insurance under the California Fair Plan. I think the maximum is 2.7 plus upgrades, making it close to 3 million. I'm actually not 100% sure that it applies to commercial like an apartment house, but I know it applies to residential property. But what, the state in their mismanagement is obviously in a situation where they're forcing income property owners to just flee this state.
Okay. And then my other question was on notices for increase of rent. Do you know if in these cities, if I have to send a notice to anyone in Inglewood, Long Beach, or Hawthorne?
Well, you always have to, if you're going to increase rent, you always have to serve a notice. How would your tenant know?
No,
regardless?
not to the tenant. I mean to some government agency like an LA city has. We have to send notices.
Well, there is a list of cities that do require every year that you list the tenants' names and what their rent is. I know West Hollywood does that. I know the city of Los Angeles does that. I know unincorporated areas of LA County. So you just have to check with the specific municipality to see what their requirements are.
Okay. All right. Thank you.
And thank you. We are moving on. Well, here's an old friend of mine, Sam. How are you today?
How you doing, Dennis? How are you?
I'm good. I see
Good.
you shaved today. No,
Yeah,
I'm
I
just kidding.
shaved. Yeah, I did. Quick question here. How would you best document the security deposit, the condition of the demise premises? Would you do it by photographs, say using the front page of the LA Times as a marker in one of the photographs, and then going around to each room, each floor, each part of the ceiling, and having that front page of the LA Times in the photograph, possibly getting the tenants in there too?
Right.
in the
Well, I
photograph?
think many cameras date stamp it anyway, but certainly you can put in the LA Times as a way of showing that this picture was taken on this date. But more importantly, the picture should be taken when you lease the unit.
Yeah.
When you lease the unit, to show that, look, all these cabinet doors were right on there and I had all these screens and look how nice this looked. Then you have the before and the after pictures, okay, as to how it looked at the end of the tenancy. And this way, when they're talking about, oh, it was like that, I didn't do that. Well, you have photographic proof. So in one of our previous shows, I did mention that please take pictures before you lease out the unit as to the condition of the unit. And then you can compare that to when the tenant does vacate.
Okay, yeah, I think so. The reason why I asked is because at the outset, the parties are adversaries, each trying to obtain the advantage of better evidence over the other in a security deposit dispute.
Right, but again, I mean, pictures are worth 1,000 words, Your Honor. I just took this picture. This is how it looked. If the tenant has any pictures, great. Let me see his pictures, but otherwise your pictures are going to win. So, and that's
Yeah.
the way it is.
Cool, thank you.
Any other questions, Sam?
That's it.
Okay, you take care. Have a good weekend. We're moving on to Valerie Young. How are you? Valerie Young, you may unmute yourself. Well, we're going to give you another chance. We have some little additional time, so if anybody else has additional
it is.
questions. Oh, you there?
I'm here.
Oh, good. Hi, Valerie.
Howard, I need to find out, this is just a question. I have a tenant is being evicted at present. I found out he has like a $1,700 light bill in this unit. I'm wondering if DWP comes after the landlord when bills like that are not paid?
Generally, no, but there are some municipalities, I know in San Bernardino, that it states that the owner of the property is responsible. I don't think that's in LA County, but I have heard that in other counties. So you might want to check, but I doubt that in most situations, you're not going to be responsible. You didn't ask for the service, and all you do is own the property. So,
Okay, I won't worry about that. Thank you.
all right, thank you. We are moving on to Harold. How are you, sir?
Dennis, hey, just real quick with Sam, I'm pretty sure you can get a phone app that will timestamp when you take a picture.
Yeah, most phones do that. They timestamp it, but then Sam was trying to be even more proactive because someone can make the argument that you gerrymandered that, you edited it some way, somehow. I mean, everybody can do anything these day and age. So in fact, yeah, go ahead.
I don't know for the video, I'm going to guess yes, but in Google, when you take pictures, there's a setting that will show exactly when it was taken.
That is true. If you have Google Photos and your camera and you have that on your camera, it will upload that to Google and it will date stamp it. But I think the newspaper is foolproof. But I don't see that coming up where you're going to have an issue where they're going to claim, oh no, that picture is not the way the apartment looks. In fact, if that happened, you could say, Your Honor, let's go right now. You can see the way it looks right this moment.
Okay, so let me get to my scenario. This is I'm owner occupied in a house, Woodland Hills, have a tenant, and I'm thinking if I need to press the button so I can take over my place, because I don't know what's going to go down with that election as far as whether they control us to the nth degree of the city council, whoever makes the laws. So if I need to press the button, I need to give a 2-month notice or 3-month notice, owner move it.
I think we talked about this, that you don't need to have a reason, and it would only be on the safety side.
Non-renewal? Huh?
Well, no, he's on a month-to-month tenancy right now, correct?
Yeah.
Okay, I would serve a 60-day notice.
And you just say in the notice.
As we discussed before, you don't need to have a reason.
I'm just trying to think as far as the letter, just I'm not renewing the lease.
Well, it's not a matter of renewing. The lease is over. It's now
month to month
into a month to month. So you just have to say, I'm terminating your tenancy, and here's a 60-day notice to quit, and that form's on my website.
Oh, by the way, real quick, if I had the lease, it was originally like a 6-month, like 5 years ago, but it converted like 4 years ago. is it still considered a 30-day lease? I mean, a month-to-month lease since it's automatic conversion?
It was a 6-month lease and now it's converted to month-to-month.
Okay, so I qualify.
Okay.
You're still my messiah, okay, Dennis?
Thank you, sir. Always nice talking to you.
Bye.
All right, we are going to move on. It looks like Margaret O'Brien has another question. Thank you, because we can take a couple more if anybody has any other questions. And Margaret, what's your question?
Hi there. I'm Margaret's son, and it's a question that's right along the same things you guys are talking about, but maybe from a slightly different perspective. In a condo in San Francisco, if an HOA has not kept the CCRs legible and up to date to Davis Sterling and recent rental laws, and they do not respond to requests to address this, and there's evidence they're preferentially enforcing the rules, giving themselves breaks, what should one do?
Okay, a little bit off topic since we deal with landlord-tenant, but again, the homeowners are the members of the association, and if the management is not handling that in a specific fashion, then they can be sued. Simple as that. So a lawsuit can be brought. I would make a demand that these items have to be addressed, and then a lawsuit can be brought.
Okay. There's no other I can write to what's it called, the Attorney General of California, supposedly in some cases, but that's kind of for nothing, or what?
It would have to depend what they're doing. If they're doing something that's truly criminal, a violation of the penal code, then yeah, I think they would get involved. Otherwise, this is just a civil dispute between homeowners and the managing members of the association.
Thank you.
Okay, let's see. We can go back to Julia Jordan. How are you? You're new today?
Hi, Dennis. How are you?
I'm good,
Thanks
thank
as
you.
always. Good. So quick question. I missed some of your intro on the security deposit, and in some of the questions, they mentioned specifics for 4 units that are under the control of an LLC. Can you speak to that for
Yeah,
me?
just briefly, right now, the law with regard to security deposits is that you can only charge 1 month's rent for any tenant coming into your unit. But there is an exception, and the exception is if you own no more than 2 buildings with a total of 4 units, then for those 2 properties, you can get a 2-month security. So let's pretend I only own 1 4-unit building. Well, in that situation, I can get a 2-month security, of a security equal to 2 months on any tenant moving in. By the way, I want to make this for people to understand. If your tenant moved in prior to July 1st, 2024, you don't have to give any security deposit back. Whatever you got, you got. But because you were in compliance with the law at the time when you took that security deposit. But coming now, so if you had just 1 4-unit building, that would be an exception. But what if you had 1 4-unit building and 1 3-unit building? Well, now you've got a total of 8 units, so you can't get more than 1 month's rent as a security deposit. But what if you put one or even both into 2 different LLCs? Then that ownership only has 4 units, and you as an individual only has 4 units. So therefore you can for both buildings, even though you have a total really of 8 units.
Okay, and when you're saying total of buildings, so on one of my 4 units, there's
It's on the lot.
Okay, so
on that
on the
one
lot.
lot. Yeah.
Okay, so on the lot, there's a front house, then there's a separate detached garage, and then behind that is the 3 units.
So you have, well, the detached garage, is that considered a proper unit?
No, it's just, it
Okay,
goes to the
so
front
then you
house.
only have 4 units on that one property, 4 living units. So you're
Right.
fine. You can go a 2-month security or security equal to 2 months anytime you lease out the property.
Okay, even though there's 3 buildings, but 4 units. Okay, thank you, Dennis.
All right, thank you. And I'm going to call it a day here. Appreciate everybody joining me on my 1-year anniversary. I guess in 1 year I'll be 2-year anniversaries. But anyway, you guys have a great weekend, and signing off. Take care.